Are you dealing with Wilkinson?
Yes, ma'am.
Let's see. Mr. Wilkinson, this is your initial appearance in cause number 25 DCCR 0260. You're charged with deadly conduct, discharging a firearm from September 13th of 2024. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, not just yet. I was going to ask if I could have a little bit more time in order to come up with more funds to hire an attorney.
So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice. Good morning. Are you Drayden Rose?
Yes, ma'am.
And Mr. Rose, this is your initial appearance in cause number 25 DCCR 0789. You're charged with the 3rd-degree felony offense of assault of a security officer from April 16th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm in the court.
How old are you?
18.
Are you still in school?
I got my GED.
You got your GED?
Yes, ma'am.
So are you working?
I'm finding a job.
So you don't just get a court-appointed attorney. So what I'm going to do, since you made bond, I'm going to reset your case for about 30 days and do a couple things. One, you need to try to get a job first. If you get a job, bring me that information on where you're working, some kind of pay stub or just something that shows where you're working. I also want you to apply for at least 5 jobs a week. And if you don't have a job, you need to bring me where you've applied. So if you're print something out or copy something from where you've gone. And then in addition to all of that, I want you to start talking to attorneys, okay? You need to talk to at least 3. They all charge different amounts. They have different payment plans. I want you to start talking to them so that when you get a job, you can see maybe what you can afford or what you can't. If you do all that and you still can't afford an attorney, then we'll talk at the appropriate time about a court appointed. If you don't do those things that I asked you to do, then when you come back, you run the risk of me raising your bond and you would have to go back to jail for not following that court order. Do you understand all of that? All right, if you'll step in front of the clerk, she'll give you a reset notice. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
I did not hire him yet. It's Cody Crenshaw.
Corey?
Well, Corey is. Cody
Uh-huh.
Crenshaw. He asked for $4,000 down.
Okay.
And as soon as I get that, which should be about 3 weeks from now.
Okay.
And I'll be able to get him hired for.
All right. You've been here a few times, so I'm going to reset you one more time. You need to get him or someone else hired before that next court date. Again, just bring that reset notice to him. He'll tell you what to do. If it's not going to work out with Mr. Crenshaw for some reason, then talk to at least 3 others. Bring me those names. All right? Step in front of the clerk. She'll give you a reset notice. Good morning. You're Presley Viltz? Did you get someone hired, Mr. Viltz? No.
I talked to a few of them.
Who'd you talk to?
I don't remember names. I just got back.
Okay. Did you write down the names?
I didn't know I had to.
Well, no, I mean, I tell you the same thing I tell everybody. Bring me back the names of the people you talk to so that I know you've tried, and then we'll discuss your options. Same words I've said for 11 years to every single person in here, so no one can ever say that I didn't say them.
Yes, ma'am.
So what part of bring me back the names of who you've talked to did you not understand?
I understood. I just forgot.
You just forgot. Okay, so you're in felony court. You don't just forget. Because if you don't do what I asked you to, then I can put you in jail right now. I'm trying not to do that. I want you to follow the rules. It's not that hard. You have 30 days. Talk to 3 lawyers. Try to hire them.
I did talk to
Who, did you talk to 3?
Yes, ma'am. I really talked to 4.
You really talked to, so when you first answered, you said you talked to 2. So be careful what you're saying. All right? And you're probably nervous right now, and I get that, but be careful what you're saying because you're saying some different things. I'm going to reset your case for 2 weeks. You need to talk to 3 lawyers. You need to bring me those names of who you talked to when you come back. If you've hired one of them by then, great. If not, I want you talking to at least 3. Don't wait till the last minute because they're in court and they have things to do. So start calling today, talk to those attorneys, bring me back who they are, how much they charge, let me know about where you're working, bring a pay stub when you come back. The more information you bring me, the better things are going to go. Good morning, you're Caitlin Talmore? And Ms. Talmore, this is your initial appearance in cause number 25, DCCR 0595. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that is from April 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So what happens is when you're in custody in jail, we automatically give you a court-appointed attorney. Now that you've made bond, I'm going to expect you to at least try to hire your own. So what I'll do is reset your case for about 30 days to give you some time to try to hire somebody. If you do get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to go visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of those you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk, she'll give you your reset notice. Good morning, you're Janisha Leonard?
Yes, ma'am.
See, and Ms. Leonard, you have 2 motions to revoke your probation, and then you have a new case in cause number 25 DCCR 0297, and I set bonds, and you've made bonds on all of those. And have you had an opportunity to hire a lawyer? Okay, so you need to get someone hired. The fact that I set those bonds at what I did, even when the state asked me not to,
Notice how tense the courtroom feels before anyone even speaks. Every step, every word from the judge carries weight. Could you keep your composure knowing a single misstep could send someone back to jail?
you've got some serious stuff going on. You need to try to get someone hired if you can before that next court date. So I'm going to reset your case for 30 days. You need to try to get someone hired. If you do, bring the reset notice to them. They'll tell you what to do. Go ahead. Well, you need to try to get a job first. And you need to apply to at least 5 jobs a week, and you need to bring me proof of that. Okay? If you do get a job, bring me some proof that you have a job. In the meantime, I'll also want you talking to lawyers. Bring me back the names of the lawyers you've talked to, at least 3, so I know you're trying. Bring me the information about that you're trying to get a job, and then we'll discuss all of your options. Okay? If you don't do that, then your bonds will be raised, especially on those motion to revoke probations. You'll be right back in jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. All right, you're Anthony Salvato. Mr. Salvato, you're here on a motion to revoke your probation, and I set a bond in your case. Let's see, I feel like we had received some letters. You were participating in the veterans
Yes,
and all of that.
Yes, ma'am.
You're still doing all of that?
Yes, ma'am.
Good morning.
Good morning.
What is your name for the record?
Catherine Branch.
Okay, and who are you with, Ms. Branch?
Probation.
Okay, thanks. Sorry. And so has he been following through and everything with regard to probation? Okay. Have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right. Are you working?
No, ma'am. I've been trying to do the program that we have. I have had a couple of interviews, which I have not been successful because of my record, my health diagnosis. It's been very difficult. I have attended some veteran work job fairs, and that was unsuccessful as well.
Okay.
So, but I have been trying, and I am seeing a employment counselor once a week.
Okay. What I'm going to do this morning, Mr. Salvato, and I'm looking back, I have some documentation from the Veterans Association and things like that with regard to when I set your bond. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. All right? Step in front of the clerk. She'll give you that paperwork. Thanks, Ms. Branch. Sorry I didn't recognize you. Good morning. You're Daryl Spencer. Mr. Spencer, did you get someone hired?
Mark Kilmer.
Did you already hire him?
I was on him today.
You're okay.
Yes, ma'am.
I had money on me right now.
Okay, did you talk to him about where you were gonna meet, or?
I told him about my case and stuff like that. He told me he could make a payment plan with me because I talked to Marsha Bowman and she told me she couldn't.
Okay, so you have the money to hire him?
Yes, ma'am.
All right, I'm gonna reset your case 2 weeks.
Yes, ma'am.
You need to get him hired before that next court date.
Yes, ma'am.
Right. Step in front of the clerk, she'll give you a reset notice.
Yes, ma'am.
Good morning, are you Adrian Housley?
Yes, ma'am.
Mr. Housley was previously in court, entered pleas of guilty to, or plea of guilty in cause number 25, DCCR 0290, to theft of property with previous convictions. It's a state jail felony. And we pled it as, no, and there were prior offenses, and so the agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections because of the criminal history before. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Any additions or corrections?
No.
All right, Mr. Walker, you may proceed.
Judge, what I thought was going to be a long argument for us, we're actually in agreement with the PSI report, and we're asking the court to follow the recommendations and place Mr. Housley on probation.
Mr. Hoffpower?
Judge, we understand in light of what the argument is and the facts of this particular case. However, the court will leave it to the court's discretion. You see his criminal history. He has been to the penitentiary numerous times. So I leave it to the court's discretion whether or not it wants to place this individual on probation or in light of his history.
The underlying, what he ended up pleading to, was it a third or a second?
Second.
Second.
2 to 20 because it's habitual.
That's what I wanted to make, okay,
Yes, sir.
okay.
And Judge, if I may, what we're talking about is over a 4-month span with all the items added up, we're talking about an amount that barely gets over the threshold for a Class B misdemeanor. A 62-year-old Army veteran suffers from PTSD, and as the PSI report shows, he's a low-risk candidate for it. He's not a threat to it. He's went 15 years from his last offense without getting in trouble. He's showing that he's capable of fitting in with society as well as an interest to better himself. And that's why we're going to ask that you put him on probation.
Mr. Housley, on paper, you sure don't look like you deserve probation with your criminal history. Mr. Walker is correct, and the pre-sentence report writer has stated and shown me that it looks like you really are doing well in so many ways. With your history, it just kind of is beyond me, though, that you would go and do something really as minor as what you did, knowing with your history that it doesn't matter how minor it is. At some point, you got to stop, or you just keep staying in prison. Are you still working at Dragon Products?
Yes, ma'am.
You've been, I mean, it looks like you're following through. You following through with your, is it the veteran services in Spindletop as well?
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Housley. I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years.
Yes, ma'am.
And I'm going to order a $500 fine and order that you follow all of the rules and conditions of probation. That will include that you are on the special.
The judge isn't just reading rules, she's testing accountability talk to 3 lawyers prove effort or face serious consequences. It's a lesson in responsibility under pressure, who actually follows through in real life.
Mental health caseload to help with any issues with regard to PTSD and the things that you're going through. You'll be required to follow all of their rules and conditions as well. There's kind of 2 sides to this, right? And so
Yes, ma'am.
deferred probation, a lot of times people see and wonder, well, why did they give them that opportunity at not having a conviction on your record when you have all the convictions? And that's for me. It's not for you. Because now that 10-year cap is gone. I didn't send you to prison. So if you do your probation right, then you won't have this conviction. And if you're successful at the end, the case is dismissed and you will be able to continue living your life like you have been, it looks like, for the last 16 years or so.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you're back in court, you're found guilty, which means you have the conviction, and I have the entire range of punishment, which is up to 20 years.
Yes, ma'am.
And on paper, that's what it looks like you will deserve at that point if you don't take advantage of this. So I hope you do. I'm going to hand you the trial court certification that shows this was an agreement I followed, so you waived any right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Yes, ma'am. Thank you. God
Yes,
bless.
sir. Thank you. You too, sir. Good morning. Are you Michael White?
Yes, ma'am.
And Mr. White, you are on probation and cause number 23, DCCR 1117, for the third-degree felony offense of driving while intoxicated, third or more. And probation sent an administrative hearing. It looks like as part of your probation, you were ordered to enter and successfully complete the safety program, and that was in order to have a SCRAM device. When you got out of safety, it looks like you obtained the SCRAM on April 8th, and then they notified probation that you were not meeting your financial obligations, and they terminated that, and so you don't have the SCRAM anymore. Is that correct? So, are you working? Why not? Where have you looked? What different places?
Home Depot Road.
Speak up, please.
Home Depot Road. Different construction company.
Okay. Has he given you notification of all of that?
He has. He also gave me an award letter from Social Security.
Okay.
He received, I think, was it $400?
It's only 220.
$220.
He's under review right now.
I can't hear you.
He's under review right now.
Okay. So that was just a partial disability.
Yes, ma'am.
Okay. Well, I guess an option is for him to come to the office more often to take alcohol tests there.
He is coming frequently. He's on a color code where he has to call every morning, and when they call his color, he comes in and does urine. He also is in the outpatient portion of safety, and they urine him frequently there as well.
But are they also doing alcohol testing?
Yes.
Okay. And everything's going okay with the
Yes, he
outpatient?
hasn't had it.
The only issue is the SCRAM.
Yes, he's going to group meetings and all that.
Do you drive? Okay. So here's what I'm going to do, Mr. White, based on your income and the partial disability, I'm going to retract that order that you have a SCRAM device. I'm going to order that you continue with the DROP program, follow all of those rules. Obviously, if you test positive for anything, including alcohol, you'll be right back in here. Also, as of now, a condition of your probation, since you cannot have the SCRAM or can't afford it.
Repetition here isn't redundancy, it's enforcement. Every defendant hears the same instructions, but each outcome depends on their choices. Court isn't a suggestion, it's a test of respect, effort, and compliance.
Is that you do not drive. So you cannot drive any vehicle at all ever without further permission of the court. So if you get to a point where you have the ability to get a car or drive, you're going to have to go through probation, request permission, and then I'll have to take a look at how you're doing and what I can do to make sure that I feel like everybody's safe. Does that make sense? Okay. Anything else you think? All right. All right. Keep doing what you're doing. Thank you, sir. All right, ma'am, you're Ashley Riggins, and Ms. Riggins was previously in court, entered a plea of guilty to unauthorized use of a vehicle in cause number 25, DCCR 0092. The agreement was for 15 months in the state jail prison. We didn't order a pre-sentence report. Is there any reason not to go forward with sentencing today?
No, Your Honor.
And Ms. Riggins, have you gotten into any trouble since your last court date? Okay. Then at this time, I am going to find that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody on this case that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right, good luck to you, ma'am. You can go back with the bailiff. Thank you, Ms. Coffin. All right, ma'am, are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor.
I have something, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay,
It's not being tracked at this point.
okay, thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her on probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right?
What do you want?
I mean, it says right here, she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which do you, as far as, what do you want?
If I can do the 60 days that they offer me and be off
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today,
Yes,
so,
ma'am. Okay, so
What-
I'd rather be reinstated.
okay,
It is a misdemeanor, you know, isn't it?
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. And obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow maybe the recommendation, you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are from the mental health standpoint.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously, I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there with,
Okay,
obviously, things that can be dealt with in therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, and doesn't like people telling her what she can and can't do. I'd ask that we revoke her.
so, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI.
Hear that bond forfeited isn't just missing court, it's an instant red flag one morning missed can turn a manageable situation into 6 figures in bail overnight. Would you risk that gamble?
And you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, ma'am. Mr. Nichols, this is Raquel Glover.
Yes, Your
Sir,
Honor.
are you Raquel Glover? And this is 24 DCCR 0232. Mr. Glover's case is set for trial to begin with jury selection on Monday the 8th. And what is the announcement?
Your Honor, the state has tendered an offer of 5 years in this case. They've also indicated through a notice of enhancement that the punishment range will be a second degree, 2 to 20, because of a federal conviction that Mr. Glover has. He's refusing the 5 years and we're asking you to continue. Is that correct?
So I want to make sure you understand. Are you ready?
Yes, Your Honor, state's ready.
And so, Mr. Glover, I will number your case for trial on that date. It's one of the older ones, so you need to be prepared. Talk to Mr. Kimler for trial. I also want to make sure you understand that after today, I will not accept that plea agreement. And so if you change your mind after today, you can enter a plea open to me or to some other agreement, but it's not going to be to that agreement for 5. Do you understand? And you want to go forward with your trial in 2 weeks. All right, stay in touch with Mr. Kimler, and we'll see you back on Monday the 8th.
Thank you, Your Honor.
All right, sir, you're Johnny Polanco Sr.?
Yes, ma'am.
And this is 24 DCCR 2168. Mr. Polanco's case is set for trial to begin with jury selection on Monday, September 8th. And what is the announcement?
I'm ready, Your Honor. This is the one the court will recall.
It is.
It is, he's not here today.
I was mistaken, Mr. Sheriff or Mr. Smith. I apologize. That the other case that he was arrested on was referred to the federal authorities, and there's still been no action on that.
All right, so we'll go forward with this one.
We're ready, Your Honor.
All right, the case will be numbered for trial. Mr. Polanco, stay in touch with Mr. And has there been any change with regard to negotiations or
Nothing
anything
more,
like that?
Your Honor.
All right, so your case will get numbered for trial for the 8th. Stay in touch with Mr. Kimler. He'll know that trial order tomorrow after the docket and let you know when you need to be back. Okay?
This is the pivotal moment Mercy versus Precedent. A man with decades of criminal history gets a chance at deferred probation. Follow the rules, no conviction, mess up, the full weight of the law comes down, high stakes, high drama. What would you do in his shoes? The court balances reality and rules, no alcohol monitor, but also no driving privileges. Compliance isn't just paperwork, it's the difference between freedom and consequences. How far should the court bend for circumstance?